Did you know you can be charged with domestic violence third degree in the state of South Carolina when you never physically assaulted anyone? Today we're going to talk about how and why that is. Hi, my name is Dale Savage and I'm a criminal defense attorney here in Charleston, South Carolina. And today we're talking about our state's domestic violence third degree laws and how they work. Sadly, South Carolina consistently ranks in the top 3 states in our nation for domestic violence cases. In responding to this crisis, our laws and punishments have become harsher, and prosecutors have been assigned specifically to tackle these cases and to prosecute them. In order for a prosecutor to establish domestic violence third degree, they have to prove the following: that you caused physical harm and injury to a household member, or you threatened to cause physical harm or injury to a household member, and you had the apparent ability to do so, and you put that person in fear of imminent peril. It is a misdemeanor offense carrying up to 90 days in jail and or a fine in the amount of $1,000 up to $2,500. That's right, if you never actually physically assaulted anyone, you can still be convicted of this charge. And let's talk about how that is. The reason for this is that the new laws not only address the physical abuse with domestic violence, but also the threats of physical abuse. The problems in prosecuting cases that deal with mere threats is the lack of provable evidence. When you're talking about something like this, you don't have any physical evidence of the manifestation of an injury to another person, and it really comes down to a credibility issue between the accused and the victim in the case. Oftentimes it's a he said, she said type scenario unless there's any kind of audio or video recording of the incident. Folks accused of domestic violence third degree can be frustrated even further that when the victim tells police or prosecutors that they don't want to prosecute the charge and want it dropped, that the state refuses to do so. Oftentimes this is called a no-drop policy. And what that means is prosecutors aggressively pursue these cases because of the persistent problem in this state, and they'll do what they can to prosecute it within the law. So what happens if a victim does not want to prosecute? If that victim refuses to cooperate with their state and their testimony is the only evidence in the case, it can make it difficult for prosecutors to go forward with the case. But that doesn't mean they don't necessarily have tools to deal with the situation. Prosecutors, just like defense attorneys, have subpoena power, and they can compel the victims to come to court by court order. Refusing to abide by that court order can be a criminal offense in and of itself. This doesn't mean that prosecutors are coercing victims, but what it does mean is that they can compel them to come to court, and if there's evidence, which there often is in cases like this these days, such as body camera recordings of what the victim stated to police at the time of the arrest, any 911 calls that they may have made, and oftentimes even written statements that they provided to police that supported the arrest in the first place. Even if a victim does not want to prosecute, a prosecutor can put them on the stand and play those pieces of evidence and ask them, is that them on the video giving those statements? That doesn't mean that every case goes to trial where a victim is compelled. Oftentimes in situations like this, there are other ways to resolve a case. Domestic violence third degree charges do qualify for a diversionary program in this state called pretrial intervention. This means that the case is taken out of the formal prosecution tract. However, to get this, the victim has to agree to pretrial intervention for the defendant. And then once in that program, the state requires that the defendant complete a 26-week mandatory counseling class. That's right, a 6-month class has to be fully completed to satisfy the terms of the pretrial intervention. If you do not complete the course within that time frame, or decide after 4 or 5 months you don't want to do that anymore, then the case will go back into formal prosecution. However, if you do complete the course, the benefit of doing that is that the case will be dismissed against you and you can get the arrest expunged from your record. Oftentimes, alcohol and substance abuse issues are at the heart of these problems, which led police getting called in the first place. Good defense attorneys know if this is an issue in your case, addressing those issues properly can have a huge impact in how your case gets resolved in the end. So, if you have a domestic violence third-degree charge and would like to talk about your case, please give me a call at 843-530-7813. I hope this video was helpful, and thanks for watching.